Hi, I'm attorney Jim Mangraviti, and I'm here with attorney Steve Babitsky from SEAK, and we're going to talk today about preparing for your expert witness deposition. Steve, why is it so important for an expert witness to diligently prepare for his or her deposition?
Nowadays, 97% of all cases are settled prior to trial. So realistically, the main ways that people testify now are at deposition. And at deposition, the expert very often has more at stake than the lawyer. The lawyer has many cases he or she can win or lose, but the expert only has one reputation. And if they mess up at a deposition, the word will get out to other lawyers, and a worst case scenario, if it's a videotape deposition, the next thing you know, it will be on YouTube.
Well, let's take the flip side of that. What can happen to an expert or for an expert if an expert witness really does well and nails their deposition, as opposed to tanking it?
Very often you will see an expert that does well at a deposition. Many times there are many attorneys there. There might be 5 or 6 different attorneys. At the end of a deposition like that, traditionally what happens is that all of the attorneys go up to the expert and will take his or her business card and put it in their briefcase. And the reason is very simple. They're impressed by the expert's performance at a deposition, and they may hire them in the future. So for an expert, if you talk about marketing, the best possible marketing for an expert witness is excelling at their deposition. If it's an hour or 2 or 3 or 4 hours videotape deposition, that's almost can be an infomercial for those expert witnesses.
All right, let's talk about the work that's done before the deposition by the expert, the investigation, the report, things like that. How does that work that's done before the deposition, influence what's going to happen or what's likely to happen at the deposition, Steve?
Well, the work you do prior to the deposition is the building blocks for the deposition. The attorney taking your deposition will have done probably a tremendous amount of work. He or she may know your report better than you do. They've been studying it for weeks or for months. They've done independent internet research on you. They've studied all the records in the case. So if you took any shortcuts during your preparation for that case, if you didn't go on site, if you didn't do the correct methodology, if you didn't do the right inspections, you didn't write a good report, all of that's going to come out during your deposition. So the spade work that you do prior to the deposition is the building blocks upon which that deposition is based. If you have a solid foundation, you're set up well for your deposition. If, on the other hand, you have a shoddy foundation, then the building may collapse at the deposition.
Now, here's a softball question for you. Would you mind giving us a demonstration, perhaps, of what can happen to an expert witness and how they can get skewered, let's say, if they've done shoddy work prior to the deposition?
Be happy to, Jim. Mr. Mangraviti, you issued a report in this case, correct?
I sure did.
Is this a copy of your report?
Yes.
Now, doctor, as I understand it, there were various medical records in this case?
Sure.
And you listed on page 2 the medical records that you reviewed, correct?
Yep, that's correct.
Okay. Now, on page 2, did you happen to list the psychiatric records?
Psychiatric records?
Yes, there are psychiatric records in this case, are there not, doctor?
I wasn't aware of that.
Well, isn't that an important thing to know if there are psychiatric records in a case that you reviewed?
It'd be a good thing to know. I don't know whether it's important, but it would it could be helpful.
Is there anything in the psychiatric record? By the way, how many pages of psychiatric records are there?
Well, I don't know. I didn't see any
So
psychiatric
there could be
records.
10 pages or 100 pages?
Or there could be no pages. I just don't know.
Well, let's assume that there are records, psychiatric records. Could anything in the psychiatric records that you didn't bother to read affect your opinion here today?
Well, I don't know. I didn't read them.
So as you sit here today, your opinion may be wrong because you never bothered to read the psychiatric records, correct?
Well, I wasn't provided any psychiatric records.
Did you ask for the records, sir?
Which records were that?
The psychiatric records. You follow me here? Did you ask for the psychiatric records,
Well,
sir?
I didn't know that they existed, so I wouldn't ask for something I didn't know that didn't.
They were
that
referenced
existed.
in the other records, sir. I have your other records, and they were referenced in the orthopedic records. Did you ask for the psychiatric records, or did you not ask for them?
I did not ask for them.
Okay. Is that a mistake, sir? Should you have asked for them?
I don't know how to answer that question.
Thank you very much, doctor.
Steve, what do you suggest expert witnesses do to prepare for their depositions?
I would recommend five or six different things. Number one, do a good job on the case. You have to do an excellent job on the case to do an excellent job at your deposition. Number two, get organized. Make sure your file is organized so that you can retrieve pieces of paper and documents at a moment's notice. At a deposition, you may be under a fair amount of pressure to come up with some answers. It's an open book test, so you can look in your file, but if you can't find the documents in your file when you need them, you can lose a case because of that. I remember when I was trying cases, I used to say that I lost a case because I couldn't find a paperclip at the right time. Touch every piece of paper in your file. Don't assume that you remember everything. These cases go on for years and years, so go through your file mechanically and touch every piece of paper in your file. You also want to prepare by yourself. You want to look at your file and think about the questions you might be asked and think about artful, honest, truthful answers, how you can answer those questions. You want to prepare with retaining counsel. And this is a bit of a problem because oftentimes retaining counsel will say that they're too busy to prepare you. You don't need to be prepared because you're an expert, whatever. And if necessary, you need to insist with retaining counsel that they spend the time to properly prepare you, because it's going to be you answering the questions and it's your reputation on the line. If you do not do well at that deposition, that can come back to haunt you in future cases and may affect your credibility and your marketability as an expert witness. And the last thing is, if and when the retaining attorney tells you he or she has no time to prepare you. They'll either say, I have no time to prepare you, or even worse, say, meet me a half an hour before at a local coffee shop and we'll go over your case. I've had that, we've both had that many, many times. Totally insufficient. You can't go over a file with 3,000 documents in a half an hour in a coffee shop. It's your reputation on the line. You have just as much, if not more, to lose than the retaining attorney. So if you can't get the retaining attorney to assist you, you should consider hiring outside help to assist you preparing for that deposition. So when it comes time to the deposition, you will excel.
All right, well, let's talk about outside help. That's one of the things that you do. Could you talk a little bit about the methodology that we employ when we prepare experts one-on-one for their depositions?
Sure. The first thing I always do when I'm working with an expert witness at a deposition, preparing for a deposition, is I always ask them, what are they concerned about? If they're concerned about an issue, it's extremely important to them. Oftentimes they're concerned about things which are really not that important. It may be they got a speeding ticket, they had a divorce 20 years ago or something which will never be brought up at the deposition or at the trial. So you need to go through that with them. Very often, they will come up and tell you things about what they're concerned about which are not in the file. And many times we both worked on situations where that first question, what are you worried about or what are you concerned about, became more important than any of the documents in the file. So that's the first thing I do. The second thing is we review the past transcripts of the expert witness and the client. And the reason is this. Most experts have given many depositions. Some of them given a lot more than others. And very often, we as experts and we as lawyers fall into a pattern where we make the same mistakes over and over again. So when we look at expert witness transcripts or videos, we see the same expert making the same mistake over and over again. It could be interrupting the lawyer, it could be not actively listening, it could be people droning on, answering in a lengthy fashion when they should answer simply. There's 50 or 60 or 70 mistakes that experts make. So by looking at the transcripts, we can tell them how they can improve. We then identify their weak spots. We go over their weak spots in the case and practice with them. And one of the most important things we do on their weak spots is identify areas which we know or suspect will come up. So a good attorney preparing an expert witness for a deposition, in my opinion, should be able to get 90% of the questions that are going to be asked. In that situation, it's the difference between when you're not prepared, going into an exam and not having the questions in advance, or if you are prepared well by somebody who knows what they're doing, having the questions in advance so you can think about them and then answer the questions at the deposition, which you'll definitely do much better. We practice with the expert witnesses. We tear them down. We give them hard questions to answer so they get used to the combative nature sometimes of these depositions, and then we build them up. And very often, and that's not hard to do because the experts recognize themselves. As we ask them questions and we practice with them, they start to get better and better. Sometimes we videotape, sometimes we audio tape, but they get better and better. And very often you start to see them smile because they know they're getting better.
Now, if you were going to schedule one-on-one training, one-on-one preparation for an expert deposition, when would you recommend that that take place relative to the date of the deposition?
Well, we rely on the client to tell them what's a good date, but we recommend generally 1 to 2 weeks prior to the deposition to give them some time to think about what they want to do with the deposition and the difficult questions, but not too far away from the deposition so they don't forget all the techniques we teach them.
Yeah, and also if they want to, if we give them homework to do, you need to figure out X, Y, and Z. They have time to do it, right?
Absolutely. Very often we go to, thank you for reminding me, we go to the deposition preparation session and we go through the difficult questions that we made up for them, and 5 or 10 questions they have no answer for. They have to go back, review their methodology, review their protocol, and then come up with an answer. And giving them adequate time to do that is important.
Steve, what is SEAK and how does SEAK assist expert witnesses?
SEAK is a testifying training company. And what we do is we provide many services for expert witnesses with regard to depositions and other areas of testimony. We have conferences and seminars that we run throughout the year, throughout the country. We also have books on depositions and cross-examination, which people can look at on our website. We have a deposition outline, which people can access for free at no charge at testifyingtraining.com. And also, what we've been talking about before, when expert witnesses find out that retaining counsel will not properly prepare them for their deposition, and when they know they have a challenging deposition coming up, what they can do is they can contact myself or you, Jim, or Nadine at our company, and we can work with them one-on-one to go over their concerns, their issues, and make sure that they excel at their deposition.
Thank you very much.